All right. Good morning, everyone.
Morning.
I have to read this script. Hello, I am Leslie Seawester, and I serve as Vice Chairperson for the Kansas Behavioral Services Regulatory Board. I ask the members of the board to respond to a roll call to signify their presence at this open meeting that is being conducted remotely by conference call and other electronic medium. David Anderson. Danielle Johnson.
And Leslie, there is someone who just joined on the phone line. Could you go ahead and announce your presence?
It's just Leslie Allen.
All right, thank you.
Danielle Johnson. Mary Jones.
Present.
Jacqueline Lightcap.
Here.
Jonna Norton.
Here.
Bruce Nystrom.
Here.
Andrea Perdomo Morales.
Here.
Laura Shaughnessy.
Here.
And Rick Steele.
Present.
And as David mentioned, Deb Stidham will not be in attendance today. I note the following staff members are also present: David Fye, Leslie Allen on the phone, and Ashley Van Buskirk. Assistant Attorneys General Janet Arndt, Jane Weiler, and Lainey Bernard, who are assigned to the board as general counsel, are also present. Next, David Fye will read a message concerning this meeting being held remotely.
Thank you, Leslie. And I just wanted to note too, Danielle Johnson joined as you were reading through the roll, so she is present as well.
Thank you. Hi, Danielle.
Morning.
This is David Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the board about its concerns, but the Kansas Open Meeting Act, or KOMA, does not require the board to provide public comment or answer questions from individuals. There will be no public comment at the meeting today to ensure adequate time for the items currently on the meeting's agenda. Because we are conducting this meeting remotely by conference call and other teleconference ability, I state for the record the following information. Because the emergency declaration that was issued for the COVID-19 pandemic has been extended to March 31st, 2021, the meeting is being conducted remotely to comply with health and safety concerns, as the board's conference room cannot accommodate social distancing for everyone in attendance. However, access to this meeting is being conducted by medium of interactive communication that allows members of the public without cost to attend the meeting through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the KOMA are not suspended. As such, we will be conducting this meeting pursuant to the KOMA and KAR 16-20-1 concerning compliance with the KOMA during the existing emergency disaster declaration. On February 19th, 2021, we sent notice of the board's meeting to all individuals who had requested notice of the board's meetings. The notice was also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials were posted to the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line "Request for the Agenda," and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend this meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. Each member of the board, staff, or presenter shall state the person's name and title each time the person speaks or votes. Each participant to the meeting shall ensure microphones, phones, and other electronic devices are on mute when the participant is not speaking. Each motion will be clearly stated before the board votes, and each board member will vote when their name is called. The chairperson will announce the result of the final vote. A statement or motion will clearly identify each member of the board or staff who the board delegates its authority to sign a binding document on behalf of the board. A recording of the meeting will be posted to the board's website. The board has the following items listed on the agenda: opening remarks by the board vice chair, agenda approval, review and approval of contract for expert witness services, review and approval of motions related to contract for expert witness, and review and approval of motions related to the Kansas Administrative Procedures Act, and adjournment. The board's agenda does not include an executive session. If the board elects to go into an executive session, the board will follow the following process. First, the board must be in an open meeting before going into an executive session. Then a board member must make a motion to recess for an executive session that is seconded by another board member. Each board member will then vote. A majority of the board must vote in favor of the motion to exercise the executive session. The chair will announce the result of the vote. The motion must contain a statement of justification for closure and the subject to be discussed pursuant to KSA 75-4319B, and the time and place the open meeting will resume. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members return to the conference call, the open meeting will resume through the conference call. The complete motion for an executive session will be recorded in the minutes. And I just wanted to remind the committee that any materials for this meeting were sent to you in terms of attached to the appointment for the meeting, and they are all posted on the board's website this morning. So,
Thank you, David. The meeting is now called to order, and the board will begin its discussion of the first item on the agenda, which is agenda approval. So a motion to approve the agenda as read this morning.
I move to approve the agenda as read.
Second that.
All in favor, say aye.
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 Any opposed? All right. So the first thing on the agenda is review and approval of the contract for expert witness services that was sent out, like David said, in your email with all the attachments. Have you all had a chance to review that?
and Leslie, if
All right.
you'd like, I can say a couple comments about the contract. And okay.
Yeah, that would be great, David. Thank you.
Thank you. Basically, one of the reasons why the contract is before you today for your review and approval, if you vote to approve the contract, is because when an individual applies for licensure under the board, if they receive their education from an institution that is not accredited by the National Accrediting Association, there's a different process that the board follows to see if that person meets the requirements for licensure in Kansas. And so in those cases where that happens, the agency will send out a questionnaire to obtain additional information, and then ultimately it will be in the hands of the board member who represents that profession for the board. However, in some situations, if a board member doesn't have the educational background or the experience in higher education, or they're not familiar with a lot of those different types of aspects, it kind of creates a strange situation where the board member is asked to do these things. And so we wanted to go ahead and provide some different alternatives to assist the board when we have situations like this come up for these types of licensure comparisons. So we did some research to see what other states are doing, and some states actually go through a private company. There is a company out in South Carolina that we looked at in terms of an alternative, and they do reviews of different applications. They have a time frame where they go from about 4 to 6 weeks per application, and they charge a pretty set amount depending upon what kind of review it is. But we wanted to look to see if there was maybe a way that we could have something that could be resolved a little bit more quickly and possibly local with someone who's had experience doing this. However, one thing that we've been trying to do is we've been trying to formalize some processes that the BSRB does. And in cases like this, it's helpful to really designate if the person doing the review is acting in their capacity as a member of the board, or if they're acting in a different capacity. So under the current way that things are set up, a board member could still do this type of review on an applicant who got their education from a non-accredited institution. However, we wanted to allow this as an alternative. And so in this case, what the contract would allow us to do is it would allow us to contract specifically with somebody designated as an expert witness who would be asked to do the level of review, make a report, and then submit that report to the board for their consideration in terms of the recommendation if this person meets the requirements for licensure in Kansas. And then I believe Jan or Jane will walk through the different provisions in the contract, but I just kind of wanted to set the stage and just kind of let you know, this is something that we worked on, and we've had some real good discussions back and forth in terms of, updating different contract provisions and trying to take into account, paper records versus electronic records. And so I think the contract is in a really good space, but I just kind of wanted to walk through how we got to this point and let you know why we believe we would like to be able to go forward with the ability to contract in these situations so that we can, go through and make sure that people continue to be licensed and also create kind of a more clear distinction of having this person as an expert witness and then having a clear separation between them in that capacity versus the board's final review and for the recommendation. I can answer any questions on that. Otherwise, I think Jan or Jane is going to actually walk through the contract and kind of explain what the provisions in the contract are and maybe why some of those are worded the way they're worded or why they were included.
I can go ahead and start a little bit. The one thing is if the board, I do want to point out that if a board member does the evaluation, like for coursework on an application, then that raises the possibility of them, if they request a hearing of that board member, perhaps having to testify, which we don't want to do. We want to keep the board members as the presiding officers to evaluate it. So by hiring an expert witness, then it allows that person to come in and to testify at a hearing if necessary. So that's kind of one of the critical things about it for applications. Then in addition, as Jane will talk about a little bit more for like CRC, when there's an allegation of maybe the practice was it, competent or those type of issues, then that way the expert again can come in and testify so that they can explain to, because usually your disciplinary matters are over before the Office of Administrative Hearing, who is an attorney, but not a licensed professional by BSRB. So by having the expert witness, they can detail, what is the proper practice and what is not the proper practice. So kind of starting off, basically the person has to be licensed in Kansas as to whatever profession it is. And they can also have license in another state, but if those licenses have to be in good standing throughout the duration of the contract. So if they do have any complaints filed or any action taken against them, they do have to notify us so that way, if we need to, we can terminate the contract, because that's not going to be real good if someone gets the license revoked and then that's pointed out on cross-examination. So they also have to provide a curriculum, current curricula vitae, which shall become a record of the board, so that way we can show what their qualifications are. Number two, that is the scope. It basically kind of tries to flush out the details of it. They can do document review, research, and then whatever they need to help the board reach their decisions. So that would be like in the application process, we give them the application file, all the supporting documents, and they can go through that to determine if courseworks do meet what's required of the statute and the regulations. The same way, then they can go through studies or research to look to see about maybe perhaps competent issues, that type of thing. They will give a written report back to the board, so that way you do have a document then that's the board can look at and evaluate to decide if they agree with it. Also, that if there is a hearing then requested in the matter, that person will testify on, so that the board can make those decisions after the hearing. The B is paragraph B, 1B or 3Bs. Move on to 3. For the document review, we ask that they within 30 days complete the evaluation and get it back to us, because under CAPA we do have some time restraints, and so we want to get that matter resolved as quick as possible. The same thing with CRC. The fees are set at $50 an hour related to it. And then, however, if they don't get the reports done as agreed upon, then their fee goes down to $40 for it. They also agree that they're going to testify, whether it be at a deposition, a CAPA proceeding, or if there be something in district court, that they would also do that. And of course, they would be paid for their time to do that. We do place a limitation on this as to what they're going to be paid, which is $1,000. However, though, if we win the case and court costs are authorized by the statute, then we can get the full cost of whatever the expert had, even if it went over 1,000, because they have to pay it. They have to provide an itemized bill then to the BSRB to get paid, so that we can show what hours they did work and do that. Let's see, we make it clear that they're independent contractor. They're not any type of state employee, so that they don't get that. The documents that we give them and that they provide back to us will be our property. And of course, then they would also necessarily have to destroy copies of anything that they are given. They also agreed that what we give them will remain confidential because they do get a lot of confidential information, such as the education records that are protected by FERPA, and then of course, medical records that are protected by HIPAA. And alcohol and treatment records also are protected by federal law. Again, and if the expert does use a third party, all of this is binding on that third party as well. Then again, the destruction of the documents. So does anyone have any questions about maybe why we're proposing this contract or what any of the terms are about?
Jan, I just wanted to point one thing out too. You did cover this, but I just wanted to stress it. So you mentioned the $1,000 for the contract. So that's the cap in terms of them reviewing the case, doing the report, and then going and fulfilling their duties if there's a hearing. The floor or the minimum amount would be $100 because they're being paid at $50 per hour with a minimum of 2 hours to do the initial review and the report. So on these cases, it could be as inexpensive as $100 to do the review, but the whole way through the process, if you're talking about the review and possible responsibilities for a hearing, that would be a maximum of $1,000. And there would be a separate contract per applicant so that you can create these kind of separations so that there wouldn't be any connection to other individual reviews. So I just wanted to kind of stress those points. You covered them, but I just wanted to clarify that for the board as well.
And also, David did talk to Gary Price, who has done this in the past for the board, reviewed material for an application and testified at a hearing. And he was saying to do the review and prepare the report was probably only going to take maybe 2 to 4 hours. I thought that was really fast. But so it shouldn't be that $1,000 for every case. That's just, the cap, but we don't anticipate that they will be that high. I believe you also have a litigation fee fund, don't you, David?
It's all rolled into the same fee fund, but there is a certain amount set aside for expert witnesses as the board needs in cases.
You've got a line item for it, and that's where it would come out of.
And I just wanted to clarify too.
I was going to say that was my question in terms of the budget. If I made the assumption that this was clear in terms of a budget line item.
Yeah, there's not a specific, if you look at the appropriations bill, there's not a specific line there because it's really just the limitation on the overall fee fund. But within the budget, there is a certain amount that is set aside for expert witnesses as needed as part of, when needed by the board. And I don't want to jump ahead too much to the motions, but these are the contract provisions that Jan went over. One of the motions would allow the authority to change a contract provision, minor changes with consultation by legal counsel for the board. And so if there is something that is a minor issue with one of these things, that would be something. So this contract is basically the template we would use. But if the board approves that motion to think about those in combination, because this is the starting point. But if we needed to, change something, I know there's been a little discussion about the fee. And if for some reason, if someone wanted to perform this service, but also wanted to decline compensation for one reason or another, that is something that could be amended into a specific contract so that someone could agree to that or other different terms. So didn't want you to think this was the complete binding contract for each individual case if you approve that motion. So I wanted to make sure that you were aware that would be coming to consider those two together.
And it does authorize, you will note, typically the board has the authority to sign contracts, but we did give that authority, as David mentioned, as you know, to the signature lines, it's going to be by David. So that way we don't have to have a meeting every time to have you approve it if you agree to the template and also to the motion to authorize him to sign on behalf of the board.
So I have a clarification. Sorry, Jan, go ahead.
Yeah, otherwise, approval, because it is the board, it would be having another meeting and having a board approve every contract, which, right now, if you've got 10 applications pending, which I think we're getting close to, I don't think you want to do that. This is not anything that's that unusual. Most executive directors or a chair usually signs these contracts.
And that was my clarification. I think David and I talked, it was, I think 8 applicants currently or something like that. So it's not a large number, just so the board knows kind of a number that we're looking at. And then another question I had is an advisory committee member, are we able to contract with an advisory committee member, or do they have to not be on an advisory committee?
There's nothing that prohibits the advisory committee member from being the outside expert witness. Main thing is that we don't want the board member to be the expert witness and subject themselves to possibly having to testify.
Well, and also I think too, for this contract, this creates a very clear distinction in terms of if they're just doing that as an additional service to help out the board in their advisory capacity, or if they are officially designated as an expert witness. If there's any kind of confusion about what role they're fulfilling, having a contract in place will make it very clear that they were authorized specifically to be an expert witness. This wasn't just a duty as an advisory committee member.
And it also gets rid of that ex parte issue, because then they submit a report and that report is available then to the applicant as to, you know, that will explain your decision if you rely on the report. Again, this would just, the report would be just evidence. And so you can accept some or all of the report. It's because that ultimate decision is up to the board.
And
I
then,
think Jane's looking for something.
yeah, I was just going to say too, just on back about why we don't want the board members testifying, is the fact that, I don't know if Jan had mentioned it, but you would not be covered under the Kansas Tort Claims Act. And that's why Jan and I like to protect you, because as long as we keep you in your little corral, you are protected by the Kansas Tort Claims Act. And then that makes Jan and I happy. And so if you guys wander outside of the corral and something happens, it would make us sad.
Jane was listening to my training. Yay, my little corral speech.
Yeah.
So we
Yeah,
can't
just have
tell
one more
Ole and
minute
Lena
left.
jokes while we testify.
Pardon me?
We can't tell Ole and Lena jokes while we testify.
Only if they ask you to do that, you know, on examination, then you can.
Sometimes I do that just to lighten the mood a little bit.
You want that a part of the contract that they have to make jokes?
Yes,
Okay.
good jokes.
Lighten it up. There any other questions?
Yeah, so this is Rick. Historically, it has been not board members, but advisory committee members who have done this, right? Because I've done, I don't know, countless of these. So it could be an advisory committee, but it could be someone else.
Typically, what we've done in the past is that we have used professors from the different colleges that are in that certain school, like in the psychologist or the professional counselors or the social work, to evaluate them. So, I mean, because they have the expertise to evaluate coursework.
Right. Do the representatives of the various professions, do they weigh in on who is chosen for this? Or is
I suppose they could, David would contact maybe that advisory board to get ideas. Again, that would be probably something you'd have to take up in an open meeting, but yeah, he could contact the advisory board to get their input on who to hire.
Yeah, so speaking as a faculty member, there are some faculty members that are licensed that I wouldn't let you do this. I would throw a huge fit. And then there are some that are reasonably good. And I just don't know. I mean, I guess, you know, the advisory board members are vetted to some degree, right? We have, at least theoretically, we have confidence that our advisory boards or have the training and understand. They've been through your training, Jan, you know, and so opening this up to any person in Kansas who maybe understands the board's function and maybe doesn't, I don't know. I just have a little bit of, I would like to see a little tighter consideration on who could be one of these contractors rather than just picking someone at Yahoo State, you know.
Well, and that's something that would be more you work out with Dave. And that's what I'm saying. He could contact the board members in that profession who So if it was psychology, then he could contact the board members who have a master's and a doctorate in psychology to get their recommendations. As long as you don't reach a majority, remember, you can talk. So yeah, I mean, yeah, he can, it's not left 100% entirely up to David. I mean, well, in essence it is, but
Yeah.
I think you just have to have a certain amount of trust in David that he's going to go to the board members or the advisory committee for that profession to help choose someone. I think right now everything is in the professional counselors that we have applications pending. And I think for that, we've used like Gary Price in the past. And I think that's maybe who they were considering of doing, or no, professional counselors. And I think that's who he was thinking of using.
Yeah, the cases that are pending right now, really they're professional counseling, and Gary Price is on the advisory committee for professional counseling. So for the current applicants, that's really what we had initial discussions about. But I have no problem at all seeking some guidance from the advisory committees in terms of individuals to use for this. So I'm open to suggestions and feedback in terms of individuals who would be qualified and able to do this to help out the board.
And I should say too, historically speaking, because I've been here since 2011, so almost 10 years, and the only two professions where this issue's really arisen has been for professional counselors and for psychologists. And why that is, I don't know. But the other professions, I don't really recall that there's been that many cases. I imagine perhaps because they get them from their degree from a school that has the accreditation. But that may just be anecdotal, but that's what I can say is typically I've seen this in psychology and professional counselors.
Yeah,
we
Jan, I had
to set it up for all the professions.
Yeah, I had a conversation with Leslie to see if there were others over the years, and I think she mentioned there might have been maybe 2 from social work over the years, and maybe 1 from marriage and family therapy at a certain point. But yeah, primarily what we have right now are some of these cases are coming under professional counseling. So that's really that was the impetus behind the contract. But the contract is a template, and so it could be used for the different professions as needed. So.
These don't happen. Well, it seems like in the last few years we have had a few of these for psychology and professional counselors from people that do go to unaccredited schools. But when you look at the number of applications, it's probably not that great, but you never know. I don't know. It seems like 10 is a lot to have, or 8 or 10, whatever it is a lot right now. That's why we need to probably get the expert help so we can get those through and finished.
Any other questions? There is a motion that was emailed. If we would like to have someone read that motion.
This is Mary. I would move that the board approve the contract for expert witness services that was discussed at the board meeting today. And I would further move that the board authorize David Fye, the board's executive director, to change any term or condition for the contract for expert witness services as necessary for a specific case after consultation with the board's legal counsel.
Do we have a second?
This is Jonna. I'll second the motion.
Thank you. All in favor, say aye.
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 All opposed, same sign. Okay, motion carries. So we have several motions. Do we just want to go ahead and go through those, board? Is that okay to move forward?
Has everyone has had a chance to review them? Do you have like any questions on any specific motion, or you just kind of want me to go through each one?
Well, I believe the next motion relates to the contract, and then after that, I think that there are 7 that are specific to Kappa. So maybe it'd be good to go to the next contract motion, and that one really relates to delegation by the board to me to go ahead and execute and enter into a contract with an expert witness for performing these services. And then it kind of says the different areas for doing that. So I thought the next one probably could be that one. And then the 7 Kappa, if one of you, Jan or Jane, doesn't mind walking through those motions, would be helpful for the board.
This is kind of what we've already discussed, is allowing David to go ahead and sign the contract. And then all of the acts are listed so that the contract would apply to all of the acts.
Would someone like to make that motion? I think I can read it, correct, David?
Yes.
Okay, I'll go ahead and make the motion. I move that the board designate and delegate to David Fye, the board's executive director, the board's authority under KSA 74-7507A4 to execute and enter into a contract with an expert witness who will perform the services stated in the contract for expert witnesses that the board discussed and approved at today's meeting. Those services include, but are not limited to, investigation, document review, studies, research, reports, and testifying as an expert witness as necessary for the board to perform its duties and responsibilities in determining the qualifications of applicants and the compliance by licensees in the following licensing acts: Licensure of Psychologists Act, the Licensure of Master Level Psychologist Act, the Professional Counselor Licensure Act, the Social Workers Licensure Act, the Marriage and Family Therapist Licensure Act, the Addiction Counselor Licensure Act, and the Applied Behavioral Analyst Act. Do I have a second?
I'll second.
All in favor, say aye.
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 Aye. Any opposed, same sign? All right, that motion carries. Thank you.
Okay, now I think we have the 7 Kappa motions, and Jan or Jane, do you mind walking through these before the board votes on each one of them?
Yeah, I can do that. The first 3 motions are basically about delegation to serve as agency head. This is language that's in the Administrative Procedure Act, so some of the terminology seems a little odd. A lot of people think the agency head is the chair of the board, but it's not. There is it's defined as an individual or a body of individuals in whom the ultimate legal authority is vested by any provision of law. The agency head comes into play. Your discipline cases are taken over to the Office of Administrative Hearing, that presiding officer there does the hearing and issues an initial order. An initial order is appealable to the board, and that is basically the agency head. So it would be the board members, the way you have it set up now, you have it so that if they do file a petition for review, then that petition has to be reviewed within 20 days. It would be by all of the board members who are not on the CRC. And then they have to decide whether or not to grant the review. And then if they do grant the review, then briefs are filed. And then you look at the briefs, you look at the record, and you have to issue an order. Because of the time constraint to decide whether or not to issue an order to review it, I've done a couple of motions here. The option 1 for the agency head is to designate your chairperson as authority to be agency head to make a determination on whether or not to deny or to grant a petition for review. This also gives them the authority to issue the other order. So they would go ahead and decide the matter, and then if after they issue their order, there's also other types of things that can happen, which is asking, filing a petition for reconsideration, a petition for stay, so that they can also review those and decide. well, I should back up on this one. They basically just kind of do the preliminary motions, which is whether or not to grant it, and then later on, whether or not to grant stays and reconsideration. But if they do decide we're going to review it, whether it's all of the issues or only part of them, then the board would conduct those proceedings. Under the second option is basically given the chair the authority to handle everything from beginning to end, from when the petition to review is filed, and then the decision, and then also any subsequent petitions, like petitions for reconsideration, petition for stay, and whatever needs to be taken on it. So those are the two options. So it's basically how much delegation you want to give to the chair. But at a minimum, I think we need to do something, because trying to get together the board members to make the determination within 20 days and to get a order issued is a little bit cumbersome. It's been a few years since you've had a petition for a review of an initial order come before the board. Probably the last one I can think of was held when you were over on Kansas. How long have you been in Eisenhower? Maybe 8 years?
Somewhere around there.
Yeah, so you haven't had, I can't recall of having one since in quite a long time. But again, they do come up. And I don't know if Jane has any hearings pending now over at the Office of Administrative Hearing. If so, this could come up. So that's why we want to throw it in there.
Jan, there was the case that you're conflicted out of was a motion for reconsideration.
Oh, that's right. There was, yeah. That was about 3 or 4 years ago.
Or 2, 3, yeah.
Yeah, I can't read time. The last year, time just has no meaning. So, yeah. But they can be kind of time consuming. So that's why we, thought that perhaps you might want to consider just having one person. And you don't have to limit it to the chairperson. I mean, you could create a committee to do this if you want to do that. Some boards have, give one person that duty to do the petition for review. And you could also have a committee if you want to, but it would require creating the committee first before you could delegate it. So it's however you would like to do that. I gave you 2 options. If you don't do anything, then it's going to have to be the getting together the board members who are not conflicted out to decide these things.
And Jan, I'm sorry to put you on the spot, but it may be helpful for the board to know, I know you work with other agencies in terms of one of these 2 options. Have you seen one of these 2 that other agencies have used? I thought that might be helpful for the board to know.
Yeah, the nursing board is very similar to, well, it's kind of similar in that they have about 11 members on their board, but they've created a investigative committee and that handles the discipline. And then they have one person who does applications, but all the hearings for the nursing board go over to the Office of Administrative Hearing. And then, so they've created one board member to do everything on a petition for review. So that is one board who just uses one person to do this. However, again, the difference is that nursing is, everyone is licensed as a nurse. It's just different levels of nursing, whereas you have different professions. So, if you would feel better about creating a committee or keeping the way it is, that's fine. But what has me concerned is getting a decision made and an order issued within 20 days. On just whether or not to accept it, not the decision on whether there was an error in the initial order, but whether or not to just even accept the petition for review.
It makes sense to me that if we're considering time issues, that we do something like option one would be sort of where I'm leaning to. There is a part of me that's a little hesitant to delegate full authority, stop to finish, to a single person. So I'm just wondering what the other board members are thinking. And I also think if we developed a subcommittee, we're almost looking at our board composition. So that might be a challenge in this as well.
They also have like alternates, but we're coming up to that issue, but yeah. But you know, this option one does give, and usually they don't really, for that, they don't really have to know too much about the profession because the arguments are typically going to be like legal issues. Did they interpret the law correctly? Was due process given? Or do the facts support what they did? Or like, okay, yeah, I did that, but I shouldn't be revoked. I should just be suspended for a couple months. Those are typically the kind of issues you would see in a petition for review. So, and that's all they're going to decide is what are we going to do on this petition? You know, and if Jane wants, she can always if she feels that no way do you need to review this, she can always do a quick response of saying, no, what they raised, there's no issue there. So, but she doesn't have to, it's not required. It's really upon the board to decide on that limited information that they put in the petition for review, whether or not to grant it.
Any other discussion or questions? And it is a rare occurrence, right? That's what we were talking about in the beginning. So that does make at least me feel a little more comfortable putting the designating one authority figure for that.
And a lot of times these are filed by pro se people. And when you read their petitions, they're just like, I want another hearing or they didn't show up and the default order was given. And so they are trying to undo that rather than take the correct procedural steps to do it. But that's, so those are pretty easy to handle with the pro se ones because they're just begging for something else, not really given a legal or a factual issue.
Well, I would lean, I'm in favor of moving forward the motion. I'm in support of option one, and I'd be willing to make a motion on that, but I didn't know if there were opinions on the board that the full, the option two would be what the board's considering.
I'm fine with option one. I think that makes sense given all the explanation, and thanks for explaining it because I wasn't exactly clear what the difference was. So I understand that much better.
I agree.
I would agree with option one for the timeliness and also.
Let me read it. Okay, is there a board member who makes the following motion? I move that pursuant to the Kansas Administrative Procedure Act, the board designate and delegate to its chairperson its authority as agency head under KSA 77527 to make a determination on whether to deny or grant a petition for review of an initial order and issue an order accordingly. If review is not exercised, the chairperson is also authorized to issue any other orders regarding a petition for reconsideration and stay. If review is granted in whole or in part, further proceedings shall be conducted by the board.
So moved.
Second.
All in favor, say aye.
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 Any opposed, same sign. Motion carried.
I'm sorry, who seconded?
Laura Shaughnessy.
Thank you.
Next motion that comes forward is basically setting up an alternative as an agency head. So right now, so if the chairperson somehow couldn't handle it, then it would go to the vice chair to serve as the alternate agency head, and they would have the same authority that was delegated to the chairperson. So you just delegated it option one, so that would be their authority. You don't grant them anything more. And an example would be like right now, I think since last Thursday or Friday, the chair's not been available. So consequently, she won't be available till next week, I think March 2nd. So consequently, if one of these had come in as soon as she was not available, over half of the time to reach that decision is gone. So consequently, what we would do would be send it to the vice chair, and the vice chair then would make the decision on whether or not to handle it. And unfortunately it has happened, where something happens to the person they delegate it to. They could have a conflict of interest. It doesn't have to be, that they're away on vacation or ill or something. Just sometimes they have a conflict. So you've got an alternate set up to handle it. So, go ahead. So is there a board member that makes the following motion? I move that should the chairperson be unable to serve as agency head, the board designate the vice chairperson to serve as the alternate agency head with the same authority delegated to the chairperson.
This is Jonna. I will make that motion.
This
Jackie,
is
I'll
Dawson,
second.
Jackie seconded. All in favor, say aye.
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 Any opposed? Any opposed, same sign. All right, that motion carried.
Next in our line of motions, it has to do with the CRC. And it really doesn't change anything than what you're already doing. It's just that you don't have that formal motion that kind of fleshes out what the CRC does and what their authority is. So if anyone would ever question it, this motion would say that, yeah, they do have the authority to issue orders. So the motion basically then, well, let me back up a bit. This one is like for the emergency. Let me read it. Yeah, this is the emergency proceedings under CAPA. And so the other things, CRC does a lot of things, but sometimes they have to do an emergency proceeding, which CAPA does authorize, which means you don't go through all the formalities. There's not a notice of hearing. There's not a lot of notice to the licensee because you have made that determination with the complaint and with what evidence you do have that time is of the essence. And if you don't suspend someone's license, the public could be harmed. And so this gives to the CRC that authority to do that emergency proceeding that's set out in the Administrative Procedure Act. So does anyone have any questions sort of how that would work? And I think Jane said that since she's been here, you've had one emergency proceeding.
Yeah.
So again, they don't happen often.
No, this does not. And that case is actually a closed case and it's available online. But what happened was the individual was under the influence of methamphetamine and was on duty as in her role. And it was actually the other party involved is when reported her, they found out. And so it's just a matter that for an emergency, you look at this, they're an imminent threat to the health, safety, and welfare of the public. And the CRC at that point thought that being under the influence of methamphetamine while on duty was an imminent threat, which it was appropriate. So we did an emergency suspension in that. And in my 3+ years, that's the only time we've done one.
My experience based with other boards is that the emergency proceedings typically do involve the use of alcohol or drugs while practicing. And it's also been that stealing property from a client and what was it? Oh, actual physical harm. They had it on tape of physical harm to a client. So that's why, they're not used very often, but you've probably got straightforward evidence that someone's been hurt. And if you don't stop it, something's else could happen. So any questions kind of on this? Okay. So is there a board member who makes the following motion? I move that pursuant to the Kansas Administrative Procedure Act, the board designate and delegate to the board's complaint review committee its authority to act as presiding officer in emergency proceedings under KSA 36 amendments thereto, including conducting any hearing and issuing an order in matters that are being or have been investigated for any alleged violation of or compliance with the following acts or regulations promulgated thereunder. The Licensure of Psychologists Act, the Licensure of Master's Level Psychologists Act, the Professional Counselors Licensure Act, the Social Workers Licensure Act, the Marriage and Family Therapist Licensure Act, the Addiction Counselor Licensure Act, and the Applied Behavior Analysis Act.
This is Mary, so moved.
This is Laura Shaughnessy. I second.
All in favor, say aye.
Aye. Aye.
Any opposed? All right, that motion carries.
Okay, the next one has to do just with applications, so that doesn't involve disciplines. So it's all of the applications under your various acts, and that would be to designate to the chairperson the authority as presiding officers under the Kansas Administration Act to basically handle pre-hearing matters and then to sign orders. So it would be to issue a notice of pre-hearing conference or a notice of hearing, conduct a pre-hearing conference, issue subpoenas, issue any orders concerning the pre-hearing conference, pre-hearing matters, or a hearing conducted by the board, and then to sign any final order after a hearing conducted by the board, and sign any orders on a petition for reconsideration or petition for stay. So they're not making the ultimate decision on the application. Those are still going to be deliberated, but they can issue the order.
Okay, so I'll read. I move that in matters regarding applications filed under the following acts: the Licensure of Psychologists Act, the Licensure of Master Level Psychologists Act, the Professional Counselor Licensure Act, the Social Workers Licensure Act, the Marriage and Family Therapist Licensure Act, the Addiction Counselor Licensure Act, and the Applied Behavioral Analysis Act. The board designate and delegate to the chairperson its authority as presiding officer under the Kansas Administrative Procedure Act to issue any notice of pre-hearing conference or notice of hearing, conduct a pre-hearing conference, issue any subpoenas, issue any orders concerning the pre-hearing conference, pre-hearing matters, or a hearing conducted by the board, and sign any final order after a hearing conducted by the board, and sign any orders on a petition for reconsideration or a petition for stay.
This is John. I'll second that motion.
All in favor, say aye.
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 Aye. Any opposed, same sign. Okay, that motion carries. Thank you.
I'm happy to go ahead and make a motion for the second one, which I think is just the delegated authority to the vice chair.
Thank you. Go ahead, Mary.
I move that should chairperson be unable to serve as presiding officer, the board designate the vice chairperson to serve as an alternate presiding officer with the same authority delegated to the chairperson.
Is there a second?
This is John. I'll second.
Okay, all in favor, say aye.
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 Any opposed, same sign. Motion passed.
And then the next one has to do with basically discipline. When someone files a complaint, or as they often refer to it as a report of an alleged violation. So it basically gives them the authority to do what they're already doing, which is to to make a reasonable grounds determination about a violation, investigate it, do any pre-hearing proceedings and hearings. So if they wanted to have a hearing, that they could, issuing subpoenas, entering into settlement agreements, issuing decisions, pre-hearing orders, summary proceeding orders that censure, revoke, limit, condition, or suspend a certificate or authorization to practice under the acts, assess fines, and send warning or reprimand reprimand letters and taking any action related thereto. It also gives them authority that if they have a matter that they think that should be sent to the Office of Administrative Hearings for a hearing, they can do that. They don't have to do the hearing themselves, and they can also then decide, no, this needs to go to the full board. And so it would go to the full board to handle a hearing and a final order. I don't think they've ever used that option. I think right now everything is being sent to the Office of Administrative Hearings for pre-hearing matters and for a hearing. So, but this does give them a little bit more flexibility to decide if they want to handle something themselves rather than send it over to the Office of Administrative Hearings.
Would someone like to make that motion? Okay, I'll read. I move that in matters involving complaints or reports of alleged violations under the following acts: the Licensure of Psychologists Act, the Licensure of Master's Level Psychologist Act, the Professional Counselors Licensure Act, the Social Workers Licensure Act, the Marriage and Family Therapist Licensure Act, the Addiction Counselor Licensure Act, and the Applied Behavior Analysis Act. The board designate and delegate to the board's Complaint Review Committee its authority under the Kansas Administrative Procedure Act to act as a presiding officer. Such delegation includes, but is not limited to, making a reasonable grounds determination regarding any complaints alleging a violation of or compliance with the above acts or a regulation adopted thereunder, investigating any alleged violation of or compliance with the above acts or a regulation adopted thereunder, conducting pre-hearing proceedings and hearings, issuing subpoenas, entering into settlement agreements, issuing decisions, pre-hearing orders, or summary proceeding orders that censure, revoke, limit, conditions, any license, certificate, or authorization to practice under the above acts, assessing fines, sending warning or reprimand letters, and taking any other action related thereto, unless the Complaint Review Committee determines that the matter should be sent to the Office of Administrative Hearings for conducting further proceedings and issuing an initial order, or the matter should be considered and decided by the board.
This is Laura Shaughnessy. I second that motion.
Thank you. All in favor, say aye.
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 Any opposed, same sign. Okay, that motion carries. Thank you. I think that's the 7 motions. Do we have any others? Mine, I don't have any other.
Nope. So those were the 7 motions for consideration. And since one of them was an option between option 1 and 2, there were 6 that were officially adopted by the board. I think that's all the matters that we had for your consideration today.
All right, any questions or discussion? All right, is there a motion to adjourn?
I move to adjourn. This is Danielle.
All in favor, say aye.
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 All right, motion carries. Thanks so much, everyone. Have a good day.
Did we have a second on that?
Oh, I apologize. Is there a second? Thank you, Ashley. I thought Laura.
This is Andrea. Second.
Sorry. All in favor, say aye.
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 Any opposed? Any opposed? All right, we're adjourned. Thank you.
Thank you.
Bye.
Bye.
Thanks, Ashley. Bye-bye.